The marvelous 3.
Yes, there you go. So what we're going to do is Jolene is going to start. She's going to talk about we're kind of doing this, we realized the subject of experts was just too big to do in one training. So we're really going to focus on ease, because I think that's where, you know, everybody gets a little panic in their heart when they get an E case. And we want to kind of, you know, assuage that problem today. And so Jolene is going to hand out or she already has out there, 2 of the best handouts you're probably ever going to get in Ladle. They're so awesome, and they are how to prepare for an E case. And then once you've done the preparation, you're going to hear that word a lot, because preparation really is the key. Then I will discuss qualifying and voir diring experts, and then Candace will end up with talking about direct and cross-examination. The only thing I want to say before we start is, to me, experts are the most fun thing in the practice of law. It's like reading a good book. It's like taking an adventure. It's really wonderful. And not incidentally, it teaches you what it's like to be one of our clients. To have somebody who won't return your call, who is arrogant and dictatorial and thinks they're God,
That's what I'm trying to say about us.
and who you're completely dependent on for your case. So, you know, enjoy that experience and realize that, you know, that's what our clients are going through every single day. The only other 2 words I want to add are Google and, again, preparation. Jolene?
All right, so I'm going to start you out. First day, you pick up a case and you realize it's an E. The first thing that you're going to do, I handed you out an E checklist. You can always refer to this. I would always keep this checklist, depending on your firm policy. You can add it, tweak it, make it your own. You should always keep that with you, and I handed out an intake sheet. I would keep everything with you at court, so the moment you pick up an E, you can just hit the ground running. First thing you're going to do is look at the allegation itself and ask yourself if the elements are met. You're going to ask yourself if the child's under 5, if it's left untreated would cause permanent physical disfigurement, permanent physical disability, death, any single act of sexual abuse which causes significant bleeding, deep bruising, significant external or internal swelling, and of course more than 1 act of physical abuse, each of which causes the deep bleeding, bruising, external, internal swelling, bone fracture, and consciousness, or willful, prolonged failure to provide adequate food. If these elements are not satisfied, the good news is that you don't have any. It's actually pretty easy. You might want to speak with a supervisor at that point about whether you need to demur the count. If you enter a general denial, you waive the right to demur, so you need to speak with a supervisor immediately. But so many times these cases are filed and it turns out it's not actually any. Situations such as you have several rib fractures on the 5th, 6th, and 7th rib. They might not have occurred. They need to prove a timeline. They may have, the dates of the injuries might be around the same time, so it's not like you're looking at 3 separate injuries. Of course, you're going to explain all the basics, the arraignment procedure. I'm not going to go through that. The allegations are going to go over FR services and whether the department is making a no FR recommendation. You're going to go over placement, and again, I'm not going to get into the details of that. I would strongly advise everybody, and everybody's firm policy will be different, to call up an investigator social worker to come down to the courthouse. Your first day on an E case is the most important day of the entire case. You need to develop a theory quickly. And so you need to spend a couple hours with your client that day to gather a social history, a medical history of the family. You need to find out all primary physicians. You need to get birth records, find out about, you know, law enforcement involvement with the family, how many times law enforcement has come out to the home, any criminal history, arrests, convictions, family law history. You need to find out who your client gets along with and who they don't. You need to find out who your allies are and who you can align yourself with quickly. Especially if you might be collaborating with co-counsel, you need to find out if your client's positions are aligned, and so that you can figure out what type of expert you may need. Your co-counsel may decide to get a pediatric neurologist. You may decide to get a pediatric orthopedist. So it's really important to figure out what type of, who's on your side and to collaborate. You need to figure out who your client support network is. You need to see if you can create any safety plans. You need to figure out who was around the child. You need to get extensive inventory in terms of names, address, phone numbers of everyone who lives in the home, the babysitter, frequent visitors, other children, teachers, school personnel, if it's a preschool that the child is going to, church. And again, develop that case theory early. Really, what we're looking at here is you will not succeed without developing a comprehensive theory of the case. Neither will your expert be effective without the viable articulated theory. So you have approximately from the date you pick up the case, you have about 2 weeks until the department knocks on your client's door asking for a follow-up interview. So in that time period, you need to develop your theory, and you need to have a really honest conversation with your client about all the possibilities of what could have happened. You need to run that theory by an expert quickly, because if you do not, if your client speaks with an investigator, and as we all know, they come up with multiple explanations as to what happened. Some clients don't know what happened, and they're speculating. They might not even been around at the time of the injury, and they provide 4 or 5 scenarios. Your expert's going to have to defend. He's going to have to explain, or she's going to have to explain what happened and why those 4 or 5 scenarios aren't a reasonable explanation for the injury. And so you're putting your client at a disadvantage. I would subpoena all the medical records after you get back from court, or have your client try to obtain them themselves. You may want to consider requesting on the minute order. Most courts already have make this order that your client is the holder of the medical and educational rights. You may want to request that the court include an additional provision in the minute order that the clients can obtain copies of all medical records. And explain to the court. Sometimes it's difficult when there's an ongoing investigation. I've had many clients go down to the hospital, and the hospital says there's an ongoing investigation, there's a DCFS case, and they won't let our client have access to records, even birth records sometimes. It sounds crazy, so just make sure that you are looking out for that and making sure your client can try to get those documents to you as quickly as possible. You may want to subpoena those documents to your office. You may want to have them go straight to the court, and really that's a case-by-case, decision. It's also based on your firm's policy, so you want to discuss with the supervisor what's the best way to get the records and where do you want them to go. You may not want them to go to the court. You may want the opportunity to review them first. Immediately refer your client to programs that day. You want to discuss with a supervisor the type of expert that you may need to retain. You might have a pediatric ophthalmologist, neurologist. You want to get into what type of expert you may need, and quickly you want to see if that expert's available. You want to run by the dates and make sure that they're available on the date of the trial. You may want to consider again setting a trial setting within 15 to 30 days just to make sure you have all of the records, just to make sure that you have a firm trial date and you have everything you need so that you can ensure that your client goes to trial quickly. A lot of these e-cases are continued unnecessarily. We should be really ensuring that our client has their day in court as quickly as possible. So I would also ensure that you have a release of information that day so that you can access anything on behalf of our client if they encounter any difficulties with obtaining the records. After the initial hearing, you can, of course, you have the right to discovery, depositions, and interrogatories. I've written all that out for you, so I'm not going to go over it. 355 objections. Consult again once you've retained your expert, and make sure, again, when you consult with the expert, you want to know all of the weaknesses of the department's expert. You're going to request the department's CV of their expert. You want to research their expert. You want to research all of the medical terminology. And you want to ask the expert, what are the weaknesses? What are the assumptions? What is it that you disagree with? And that is extremely, extremely helpful. And also, kind of going back to the interviewing all family members and visitors that frequent the home, you want to make sure that you interview all potential witnesses. A lot of our cases, we don't have an explanation. And I can recall in one of the RE cases that I was on with Mr. Alanick, we had a case where we had absolutely no theory as to what happened to the child. Parents had no criminal history, they've never had any referrals. All we had was a babysitter, and the child suffered a seizure while in the custody of the babysitter. And so we tried to contact the babysitter was refusing to cooperate, and it wasn't until we brought the babysitter to court that we were able to ask her a few questions, and we found out the department failed to fully investigate the case. That was our theory. So look for things, signs, people who are not cooperating with you. Try to contact everyone possible so that you can have develop a theory early on. Sometimes you might not have one, but you have to try. You might have to call a witness that you might think is responsible for the injury. You might not have a lot to go off of. Review the medical records in their entirety. There might be clues in the medical records as to what your theory of your case is. And again, thoroughly prepare your client to testify at trial. So there's a checklist for you in the back that kind of gives you a rundown of what you need to look for. Birth records, the dates that they're subpoenaed, received, discovery, 355s, the name of your expert, whether you've consulted with your expert, you have a letter, you've submitted it to all parties, you've secured your expert to testify. I have the intake sheet for you, and again, just make it your own. It really is comprehensive. A lot of the clients won't understand a lot of the terminology on here, but you can see what they do know may surprise you, so you can try to go over as much as possible with that in court. So at this point, I'll hand it on over to Dennis for the the qualification and voir dire.
Hi.
Jolene, are there any circumstances that you would advise your client not to?
Absolutely, and I should have gone over that part. I really encourage, I think the best policy on these e-cases are to not have them, to advise the client not to be interviewed. You definitely need to let them know about potential law enforcement involvement, not to speak with anybody involved in law enforcement. I don't think there is much of a benefit for our clients being interviewed in the jurisdiction disposition report. Again, it's going to be a case-by-case basis. It's going to be a firm policy, but you do not want your client to speculate as to what caused the injuries, especially if you haven't run that theory by an expert. And to do that within 2 weeks is next to impossible. And that's when the social workers start preparing the report. So I would always advise, I think the best practice is to advise your client not to interview the social worker or to request that an attorney make themselves available for the interview. Any other questions?
Along those lines, I would also suggest that they not get involved in individual counseling.
Well, I think you can advise your client, and again, it's case-by-case basis. You can advise your client that if they're going to be involved in counseling, not to sign any release of information for the department, but that may be something that you want to consider.
Okay. So, this, I don't know how many of you have seen this. There are many of these floating around. We haven't had NEDA training in about 5 years, but you'll be able to find these in your firm. The older attorneys will have them from that NEDA training. And on page 198 of this, it does a real thorough chapter on qualifying and voir diring experts. I'm not going to repeat that information because it's in there and I think you all have access to it. But what I am going to do is go into some specifics that happen here. So when you're qualifying your expert, what you're doing is trying to qualify them under the evidence code as somebody with special knowledge about the facts of this case. So you're going to put them on the stand, you're going to ask them 3 questions. Please state your name, Dr. Grogan. Have you been retained as an expert in this case? Yes. And did you formulate an opinion as to the cause of baby boy's injuries? Yes. And then that's it for that. Now, everybody knows now that there is an opinion coming down the road. And the question is it, you know, biking along on a tricycle, or is it a 14-wheeler? And you're going to try to, you know, make this as important an opinion as possible. So you start with their education, and I can't really overestimate this. We often find ourselves in situations where county council says, we'll just stipulate to the qualifications. No. Our gut should say no. Our instinct should say no. Our most common response should be no. And I hope when I'm done, I'll have done a good job if you understand why. And it's not just because we want to build up our own expert's opinion, but it's also because we want to create the groundwork to attack the other expert's opinion. So in my mind, my motivation for this section on qualifying your expert is the attorney who had the expert is no longer here, so you don't have to worry about who it was. But we had Dr. Grogan on the stand, and Dr. Grogan was found by the bench officer not to be an expert in reading x-rays. Not sufficiently, at least, to contradict a 4-year radiologist. A radiologist with 4 years of experience. That should never have happened. I think we can all agree that should never have happened. And it wouldn't have happened had Dr. Grogan been properly qualified. But if you know that your whole case is going to come down to, you know, whether that little dark mark on that x-ray is a fracture or not, then you need to talk to Dr. Grogan about his qualifications to read x-rays. And you need to really focus on that. And so keep that in mind as I go over this. So you're going over their education. If it's not that impressive, you don't need to waste time with it. We're trying to hit the high points, and we're trying to hit the areas that are relevant to the specifics of this case. So, you know, if you went to Princeton, though, you know, that's kind of impressive. Especially if you went to your bench officer's alma mater, you definitely want to include that. You know, if you know that your bench officer was an Eagle Scout, you definitely want to find a reason to wave around page 2 of Dr. Grogan's CV, right? You know, an Eagle Scout is not going to disbelieve another Eagle Scout. It's just not going to happen. So you need to know a little bit about your bench officer, and you need to know a little bit about your expert. So be curious. Everybody in our firm knows that's my #1 rule. Be curious. Find out things about everybody in the case. So, you know, what classes did they take, though, in med school that are relevant to this case? So then you go from education to training, and again, you're going to be specific. Was their residency, was their internship in a place that gave them experience directly relevant to this case? If so, you want to ask them about that and get that on the record. And then their experience, and obviously you want them to have seen 1,000 5-year-old kid or 4-year-old kids with exactly the same injury. You know, that would be perfect. But, you know, you get as close as you can. That's just the goal. And you also want to get them to have hands-on, clinical. And this is where you might want to ask a Dr. Grogan or someone like him, are you a primary treating physician? And if he says yes, then you say, well, what is that? What does that mean? And then he'll explain that that means that he, you know, has patients who come to him with a complaint. He takes their history, he diagnoses the complaint, he prescribes treatment, he follows up on that treatment, he refers them to tests, he refers them to consultations, and he follows their care until the issue is resolved, from beginning to end. The county's experts often will not be able to say that. They won't, in some cases, I don't think that they can say they ever did it, with one expert I'm thinking of. And then special skills. Really, you know, you need to ask them because they'll forget to tell you. It's crazy what they'll forget to tell us. But a lot of experts that we have here in LA, you know, we've got UCLA, we've got USC, we've got, you know, a great pool of amazing doctors. They may have special skills. They may have just created a technique. It might be as simple as that, but it might happen to be a technique that is relevant to your case and shows that they have, you know, extra knowledge above and beyond on this case. They might have been the first to perform a surgery, or they might have just done research that's on the cutting edge. Again, that's huge. If they've done some research that's on the cutting edge, that can put them heads and tails above, you know, the department's expert who's just been plodding along, doing the same thing, seeing the same kinds of kids.